All right, it's case number 24-CR-020, State of Ohio versus Stephen Dwayne Kingsolver. Are you Stephen Dwayne Kingsolver?
Yes, sir.
Are you appearing there? Is that from the probation department? Okay.
Yep.
All right. And I have a question, Mr. Kingsolver. Is your name, middle name spelled D-W-A-N-E?
Yes, sir.
All right, because I've not seen that spelling before. All right.
Yep.
This is a hearing being conducted by Zoom. Mr. Kingsolver is appearing from the probation department. His attorney, Danielle Woods, appearing on her cell phone. Appearing on behalf of the state is prosecuting attorney Collins. The defendant is charged with counterfeiting, 2 counts, and 2 counts of theft by deception. This matter is set for a plea, and Ms. Collins has the alleged victim or victims of the offense has been notified of the time, place, and purpose of this hearing.
They have, Your Honor, and I'm reading my paper now somewhere. I don't know what I did with it. Oh, I have no idea what I did with the thing. Do you have it over there? Do you have it?
It's on top of it.
I know, but I don't know what I did with
Neither
it.
one of them are appearing then?
No, Your Honor.
Okay. All right. Now, Ms. Witt, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
We are, Your Honor.
And you're in agreement with that, Mr. Kingsolver?
Yes, sir.
All right. Now, I'm holding in my hand a plea of guilty form that's prepared by the prosecutor's office, and it has it's a form that they use and then they complete it. And I'm going to hold up the first page, which says you're going to plead guilty to counts 1 and 3, counterfeiting. I'll hold that up to the camera and ask you if you recognize that first page of this agreement.
Yes, sir.
All right, and then on page 3, there is a sentence about halfway down the page. It reads, "I enter this plea voluntarily." Below that is a line for which is underneath which is printed signature of defendant for the defendants to sign. And I'll hold that up to the camera and ask you if that is your signature.
Yes, sir.
When did you sign this document, Mr. Kingsolver?
This morning about, I think it was about 8:50.
All right. And you were with your attorney when you signed it?
No, she wasn't there at the moment. The secretary was, I do believe.
And you and she discussed this before you went to her office to sign it?
Yes, we did.
And you, when you read it over, is this what you expected it to be from your discussions with her?
Yes, sir.
And did you have enough time to fully consider the matter before making the decision to sign it?
Yes, sir.
And did you sign this agreement voluntarily?
Yes, sir.
And are you going forward today to plead guilty voluntarily?
Yes, sir.
All right, now the agreement states, as I said on page 1, that you're going to plead guilty to counts 1 and 3 of the indictment, both of which are counterfeiting under section 2913.30B2 of the Ohio Revised Code, a 4th-degree felony. It further states that you understand that the penalty for those could be a minimum of 6 months and a maximum of 18 months and a fine of up to $5,000. And if the sentences were imposed and served consecutively, that would be a maximum of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony in any other case or any other jurisdiction?
No, sir.
Now, under the law, if you should be sentenced to prison and serve a prison term, upon completion of that prison term, the law provides the Adult Parole Authority has the power, if they choose to exercise it, it's optional, to put you under what's called post-release control supervision for a period of up to 2 years, meaning you'd be supervised by a parole officer in the terms that they set. And if during that period of time they determine that you had not complied with those conditions, they have the authority then to make you go back to prison to serve a sanction or a punishment for violating those conditions of up to 9 months for any single violation, but there is a cap or limit of half of whatever the prison term was for all violations. But if you committed a new felony, then in addition to whatever sentence a judge in that new case can impose upon you, that judge could also sentence you for committing that new offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence in the new case. Do you understand that?
Yes, sir. I understand.
Now, I'm not required to sentence you to prison for these offenses. I can put you under what's called sentence you to a term of community control, which most people understand as probation. That means that instead of going to prison, you'd be put under supervision of a probation officer for a period of up to 5 years under the term set by the court. Now, if during that period of time the probation department felt that you were not complying, they would have to file a written notice of that with the court and give you a copy. There would be a hearing, and you'd be entitled to be represented by your attorney at that hearing. If the outcome of the hearing was that you failed to comply, then at that time, the court could revoke your community control and sentence you to as much as 36 months and fine you $10,000. And if your community control were to be revoked in part or in whole because of a conviction of another felony, and you were sentenced for that felony conviction, that sentence could also be ordered to be served consecutively to the sentence in these cases, or in this case. Do you understand that?
Understood, sir.
All right, now, the first count alleges that on or about December 14, 2023 in Highland County, Ohio, you did, with purpose to defraud or knowing you were facilitating a fraud, pass, utter, sell, purchase, conceal, or transfer any counterfeit obligation or other security in the United States, violation of section 2913.30B2. And then count 3 alleges the same thing, except it alleges that it occurred on August 30, 2023, and in that case, a Jennifer E. Hara also acted with you. Yeah, those are the 2 charges. Do you understand what it is you've been accused of, what the state said you did, when, where, and how they alleged you did the act in each count?
Yes, sir, I understand.
And you understand the possible penalties?
Yes, sir.
Have you discussed the nature of those charges, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty today?
No, sir.
Now, on page 2 at the bottom, there are several sentences that are printed in bold and underlined, and I'll read those because those are the substantive portions of the plea agreement. And it reads, defendant shall enter plea of guilty to count 1 and count 3. State will dismiss the remaining counts. State and defense jointly recommend community control and substance abuse treatment. Defendant agrees to cooperate fully in the prosecution of the co-defendant. Defendant agrees to make restitution to Pizza Hut in the amount of $40. Defendant agrees to make restitution to Shell gas station in the amount of $500. Joint several with Jennifer E. Hara. Is that your understanding of the agreement?
Yes, sir.
And does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
As a point of clarification, Ms. Collins, the Shell gas station, is that the one in Greenfield?
It is.
All right, because I'm going to say I know we didn't have any anywhere else, so. All right, and the Pizza Hut, is that Greenfield or Hillsborough?
Greenfield.
All right, so you understand that?
Yes, sir.
Okay. Now, under the law, Mr. King-Solver, the matter of sentencing is up to the judge, not the parties. And so even though there's an agreement that you should be sentenced to a specific sentence, the court is not obligated to follow that recommendation. So once all the information is presented in the pre-sentence report and in court, if I decide that that's not the appropriate sentence under the law and the evidence, then I could sentence you to a prison term of anywhere from 6 to 36 months, and I could fine you as much as $10,000 in addition to making you pay restitution. Do you understand that?
Yes, sir, I understand.
And Ms. Witt, the amount of restitution is stipulated?
Yes, it is, Your Honor.
All right, thank you. Now, Mr. King-Solver, do you hold any type of license or certification from any government agency that regulates any occupation or profession?
No, sir.
Okay. You have certain constitutional rights you must understand before it can accept a plea from you of guilty. First, you have a right to counsel. Ms. Witt was appointed to represent you since you did not have the funds to employ your own counsel. Now, she wasn't appointed simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So, if you decide that you do not want to plead guilty, that you want to defend and fight the charges, she'll continue to represent you, including a trial, if that is what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial on these charges, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence will be presented. They'd then be instructed on the law by the judge, and if they determine that, and then they would determine by unanimous vote, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, and in that case you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to cross-examine the witnesses against you in open court through your attorney, as well as to confront them in open court. What that means is the witnesses have to come into court and appear in front of you and the jury and everyone else is here and testify. After the prosecutor's done asking those witnesses questions, then your attorney can ask questions. That's called cross-examination, the purpose of which would be to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
All right, now under the Constitution, Mr. Kingsolver, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily or can come in voluntarily, at your request, the court issues a court order that's called a summons or a subpoena, and that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination. What that means is that no one can ever make you testify at any time in the proceeding in this case. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify at any time, including the trial, cannot be used against you in any way, at any time, by any person. And in fact, no one's even allowed to comment about it except in one situation. If there's a jury trial and you decide not to testify, the judge does instruct the jury that because that is your constitutional right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense. So what that means is that the burden isn't on you to try to prove you're not guilty simply because you've been accused of this crime, or these crimes, I should say, the 2 counts. In fact, at trial, you're not required to produce any evidence to defend yourself. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each of these 2 offenses, and they must do that by proof beyond a reasonable doubt, which is the highest burden of proof that is known under the law. Do you understand that?
Yes, sir.
All right, now originally you entered a plea of not guilty. A not guilty plea denies the allegation in the indictment, all of them, denies you committed any crime, exercised all the rights I've just described. If you change your plea from not guilty to guilty on counts 1 and 3, that plea is the opposite of the not guilty plea. The guilty plea admits the allegations in each count, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you and cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. It waives, gives up your privilege against self-incrimination because you're the one saying you're guilty, so that's what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances, you may file an appeal, but that would have to be filed within 30 days of your entry of sentencing being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Kingsolver?
Yes, sir.
Now, you have any questions about the charges in either count or the penalties?
No, sir.
And you understand them?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And you understand the recommendation on sentencing is not binding on the judge?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No,
You
sir.
understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
Now, I didn't tell you this at the beginning, but if you need to speak with Ms. Witt about anything before we go any further, I can put you and her in the breakout room. It will be just the two of you talking. No one else will be able to see you or hear you. So do you need to speak with her about anything before we go any further?
No, I'm good with her advice.
All right, do you have any questions about anything I've explained to you here today?
No, sir.
Then is it your decision, Mr. Kingsolver, to voluntarily withdraw your plea of not guilty and enter plea of guilty to counts 1 and 3 pursuant to the terms of this agreement?
Yes, sir.
And I forgot whether I asked you this, so I'll just ask it to make sure. Are you a U.S. citizen?
Yes, sir.
Okay. All right, then. As to count 1, which alleges on or about December 14, 2023 in Huntington County, Ohio, you did with purpose to defraud or knowing you were facilitating a fraud, pass, utter, sell, purchase, conceal, or transfer any counterfeit obligation or other security of the United States in violation of section 2913.30 B2 of the Ohio Revised Code, the charge of counterfeiting, a 4th-degree felony with a penalty of possible 6 to 18 months imprisonment and a fine of up to $5,000. How do you plead?
Guilty.
As to count 3, which alleges the same offense occurred except it occurred on August the 30th, 2023 in this county. Otherwise, it's exact same language, except it also alleges that in addition to you committing the offense, Jennifer E. Hara acted with you. Otherwise, it's the same offense, the same penalty, same language. How do you plead?
Guilty.
All right, thank you. Court finds on this day in open court, the defendant was advised of all of his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Plea is accepted and ordered filed. Defendant is found guilty of counts 1 and 3. Counts 2 and 4 are dismissed. The matter is referred to the probation department under the same bond. Court is ordering that the report include an assessment for substance use disorder and any mental health issues. So as soon as we're done, then you'll need to make an appointment with Mr. Arjima or whoever else will be designated to do that. One of the things is you're going to have to be evaluated for substance abuse treatment. And I'm just looking here that you've been testing positive every week, 3 out of the last 4 weeks, for meth and amphetamine, 1 case MDMA, which is ecstasy. And so it's probable you're going to be recommended for residential treatment. I'm not positive, but based on my experience, it seems that may be well likely since you've been doing it while you're on community or on pretrial supervision. If that is, my suggestion is that you enter into treatment prior to the sentencing, because that tells me then that you're serious about trying to change. And if you wait until the sentencing and haven't tried to getting sober, because again, people only get sober and stay sober and quit using drugs if they do it on their own. We can't make them. We can tell you to go to treatment. We can tell you to comply with treatment. But in the end, it comes right down to you. And so if you want me to give you community control instead of going to prison, whatever the treatment is, whether it's outpatient, intensive outpatient, which would mean maybe every day for 2 or 3 hours, or if it's inpatient, whatever it is, my recommendation is that you start it when they have a diagnosis for you. And you can talk to your attorney about that, and she can explain that better probably for you. Let's see now, when is it you're going to be out, Ms. Witt?
The last week of April, first week of May.
All right.
So April 27th through
Okay.
May 5th.
So let's
something
shoot
like
for
that.
May 16th, sentencing date at 1 p.m.
Okay.
And you're still under the pretrial supervision conditions, Mr. Kingsolver. All right. Anything further from counsel?
No, thank you, Your Honor.
All right. Then just see the probation department and make arrangements for your pre-sentence report as well as your evaluation for substance use and possible any mental health issues might go along with that. All right. Thank you.
Yes, sir.
All right. I believe this is going to be the session for all afternoon, Ms. Collins, so I'm just going to mute. All right. here comes Mr. Bennett. We'll do Mr. Hunt first. All right. 24 CR 006, State of Ohio versus Jonah Michael Edwin Hunt. You're Jonah Michael Edwin Hunt, appearing there from the jail.
Yes, Your Honor.
All right. This is a hearing being conducted by Zoom. Mr. Hunt's attorney is Clyde Bennett, appearing by his iPhone, it looks like, or phone, smartphone, and appearing on behalf of the state is Prosecuting Attorney Collins. The defendant has been indicted and charged with 4 counts of rape, and Ms. Collins has the alleged victim or victims of these offenses been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor, the victim and her family are aware, and they are not going to be attending the hearing.
All right, thank you. All right, now, the reason this is before the court is that this case was set for trial originally on March 25th and 26th, and Mr. Bennett had been in trial, and there was an issue, I believe, that resulted in the court continuing the matter, and I believe we now have a trial date of May the 20th is what we set, May 20th and 21st. Is that correct, counsel? Okay. Now, Mr. Bennett, the reason I wanted to have this hearing on this, and then also Mr. Coleman, is that you've been giving my assignment commissioner fits, her trying to track you down and emailing you and then trying to call you and waiting, and when she complains to me, that makes me unhappy. So if she's unhappy, I'm unhappy. And if I'm unhappy, somebody else is going to be unhappy. So we need to make sure you understand that when you get you check your emails, because we email, that's why we require counsel in this court to put their emails on, because it's easier to get emails out to people quickly rather than trying to call them, because we have less time to call and you know, our phones are busy, and so people call us back. It's not as efficient. So check your emails, respond to the emails in the future. Now, what I instructed her to do, because we're having so much trouble, was just go ahead and set the date. But I want to make sure this is a firm trial date. So, is there any problem with the 20th and 21st of May?
No, Your Honor.
All right. So that is the date for Mr. Hunt. And we've already had our final pretrial, I believe, right?
I believe so, Your Honor.
I am pretty sure we did, back in March. All right. So unless there's no other matters pending on neither party have filed any motions, correct?
That's correct.
All right. You have no pending motions, Mr. Bennett?
No, Your Honor.
All right. So I'm not going to send any further hearings. Now, a policy for this court is that you know, any plea agreements need to be put on the record 2 weeks prior to trial, so we can avoid the problem of getting notices out and then people changing their lives and then finding out at the last minute it's been continued and or settled and they don't have to appear, and you know, we change our calendar. So we're a smaller county. We're not like Cincinnati where you got jurors that are sitting in a pool you can call on any time. And so, you know, because those folks are already, you know, they have to be there for that 2 or 3 week block, whatever it is that they're on. All right, so that'll be fine then. So that case is good. Now, and 2 days is going to be enough to try this, Ms. Collins?
I believe so, Your Honor, yes.
All right. You have any reason to believe otherwise, Mr. Bennett?
None.
Okay, thank you. All right, I think we're good then. Mr. Hunt, your trial date's going to be May the 20th. I believe that, and also for the record, Mr. Bennett, you did file for the request for the continuance because of your trial in that other case and waived the time, correct?
Yes, I believe a time waiver has been executed, Your Honor,
All right.
and filed with court.
It may have been. I haven't looked up it. You understand that, Mr. Hunt? You're in agreement with that?
Yes, Your Honor.
All right. Because I know with your attorney schedule, you wanted him to represent you, we had to continue it because he was tied up in a murder trial, capital case, I believe, wasn't it, Mr. Bennett? And so, obviously, those take priority. So, all right, so the record reflects the defendant's in agreement with the time waiver. All right, anything
Judge,
else? I'm sorry, go ahead, Mr.
I'm
Bennett.
sorry, Judge, I didn't mean to cut you off. I would like the record to reflect that as soon as I got a call from your office, I did respond to it.
Yes, you did, yeah. But like I said, the problem is phone calls for us are much more difficult.
Right.
You know, we have two lines and people are calling in all the time, and when we make a phone call, when somebody calls back, sometimes they can't get through, and then it's a lot easier for our people. I mean, we can send emails while we're talking on the phone, so that's our preferred method of communication. So I just want you to please check your emails, especially when we get closer, if there's things going on in the case. All right.
I will do so, and she advised me that was a preferred method, and I told her I'd be checking my emails for her.
Yeah, and she did tell me that, yeah. She's okay now, so I'm okay. All right. So, all right, thank you.
Thank you.
All right, the next case then is Mr. Coleman. I believe Mr. Coleman's there at the probation department. All right, case number 23204, State of Ohio versus Ryan O'Neill Coleman, and you're Ryan O'Neill Coleman appearing from the probation department?
Yes, Your Honor.
All right, this is a pretrial conference. Mr. Coleman's being conducted by Zoom. Mr. Coleman's attorney is Clyde Bennett. He's appearing on a smartphone and also appearing on behalf of the state is Prosecutor Collins. The reason for this was a motion that was filed to continue the case by Mr. Bennett. Let's see, I'm looking at that date. The trial date, I believe, was set for April 8 and 9. And so the court is granting the well, first of all, I have to back up. The defendant is charged with 2 counts of compelling prostitution, 1 count of disseminating matter harmful to juveniles, and 1 count of attempted corrupting another with drugs, 1 count of trafficking of marijuana. Ms. Collins, have the alleged victims of victims of these offenses or their representatives been notified of the time, place, and purpose of this hearing?
They have, Your Honor, and they will not be appearing.
All right, thank you. All right. Now, my understanding from your motion, Mr. Bennett, is that while you do have that time available, because of the 4 weeks you spent in that case in Claremont County, you hadn't had time to consult with Mr. Coleman and properly prepare. Is that correct?
Correct, Your Honor.
All right. Is there anything you would like to add to that?
Nothing, Your Honor.
All right. Now, Mrs. Collins, on behalf of the state, have you talked to the alleged victim or victim's representatives regarding the matter?
Yes, Your Honor, and we have no objection to a continuance.
All right. Well, as the record reflects, we also have another jury trial scheduled on Monday that's going, and so and that person's incarcerated, so that case would have priority as well, regardless of what the circumstances were, but I appreciate that. So the court will grant the motion, and now we need to check your calendar, Mr. Bennett.
I've got it in front of me.
Okay. So, let's see. This case was indicted in December. What about April the 29th? Had a whole bunch of civil juries scheduled, and they've all either been settled or continued.
I've got a matter in Scioto County in front of Judge Coon that's about 2 or 3 years old, and we're going to start trial that day on Monday, April 29th in Portsmouth, Ohio.
You're starting trial that day, you say?
Yeah, in front of Judge Coon in Scioto County in Portsmouth, Ohio, on
All right.
a 3-year-old.
Yeah, I know Judge Coon. Yeah. All right. How long is that trial, Mr. Bennett?
It's a co-defendant. It's pretty complicated. I would think. Well, we have it booked for 3 to 5 days.
All right,
Pretty much the entire week.
gotcha. May the 9th.
Thursday. Do you think this will be a 2-day trial?
Do you think it's 2 days? Okay.
Yeah,
Well, I can't do it then because I've got drug court the next day.
I'm sorry, Judge. You did say May 9th, didn't you?
I can't do it that, I can, if it's not a one-day trial, I can't do it that day. So,
I don't think it's more than a 1-day trial, though.
you think it's a one-day trial?
I've got a witness. I don't know how many witnesses. Well, I do know how many witnesses.
Yeah.
I think we can do it in 1 day.
Well, I get 90% of mine done in one day. What do you think, Ms. Collins?
I mean, we probably could, but I'm going to tell you that you have a trial set that day already.
Oh, we
That,
do?
You moved to that day because it's a sexual assault trial that hadn't gone yet.
Who was
Also
that?
an
Which one is that?
Hips.
I'm sorry, who? Hibbs?
Yeah.
Oh, okay, well, then we're gonna have to keep it that day for that then, so, all right, so, we already have you here on the 20th and 21st. So I'm gonna have to go into June.
That's not.
What about June the 3rd?
Judge, any way we could do June 5th or June 6th?
June 5th is my normal sentencing and pretrial day, and we've already got stuff set for criminal case. Let's see. Wait a minute. Yeah, no, this is criminal day. Yeah.
Thursday, June 6th, Your Honor?
Yeah, I could make that work, but then I have I can't do June the 7th. What about June 10 and 11?
That's fine, Your Honor.
All right, June 10 and 11 it is. All right, that's the last continuance. All right, and I believe we've had the final pre-trials on this as well. So
We have, Judge.
all right, so, and there are no other matters pending, correct? Ms. Collins, you have anything?
No, Your Honor.
And you have nothing else, Mr. Bennett?
No, Your Honor.
All right, so we'll just set it for trial and expect it to go to trial then unless we're notified to the contrary at least 2 weeks prior. Again, Mr. Bennett, if there's going to be a plea, it needs to be on record the 2 weeks prior to because we send out our jury notices 2 weeks in advance, and then, people change their schedules and start calling in, and, like I said, we clear the calendar, clear the court for that day, so it's important that we know if there's going to be a resolution, it'd be 2 weeks prior. Okay, anything else then, counsel?
Nothing, Your Honor.
All right, thank you. You can go ahead and
Thank
sign
you.
off then, Mr. Bennett, and
Thanks.
Mr. Coleman, you can go ahead and see the probation department if you need to. All right, let's see here. Case number 24 CR 24, State of Ohio versus Justin H. Stevens. And you're Justin H. Stevens, appearing there from the jail.
Yes, sir.
All right. Mr. Stevens' attorney, this is a Zoom hearing, and Miss Catherine Hapner is the defendant's attorney appearing from her office. Appearing from the prosecutor's office is prosecuting attorney Collins. The defendant's charged with trafficking in a fentanyl-related compound and possession of a fentanyl-related compound. I believe this matter was scheduled for a pretrial tomorrow, and Ms. Hapner called this court this morning and said due to the high volume, she would be willing to try to work it in today, and so we've done that. Now, Ms. Hapner, do you and your client both agree that this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, we do.
You're all right with that, Mr. Stevens?
Yes, sir.
All right, since you're not seated in the courtroom next to your attorney, if at any time you need to talk to her, ask her a question, just tell me. I can put the two of you in a breakout room. It'll be just the two of you on the screen communicating. And while you're doing that, the deputy will step out of the room so you have privacy and confidentiality with your attorney, okay?
Yes, sir.
All right. Now, the defendant is charged with trafficking in a fentanyl-related compound, fourth-degree felony, and possession of a fentanyl-related compound, fifth-degree felony. I believe, like I said, this is scheduled for pretrial tomorrow, and I believe we're set for trial on May 6th. All right, Mr. Stevens, I've been presented with a plea of guilty form that indicates you're going to plead guilty to count 1. I'm going to hold this up to the camera on my computer, as has your name, case number, and the guilty plea. Do you see that?
Yes, sir.
And do you recognize that, Mr. Stevens?
Yes, sir.
All right, on page 3, there's a sentence that reads, I enter this plea voluntarily. About halfway down the page, below that appears to me to be a signature of Justin Stevens. I'll hold that up to the camera and ask you if that is your signature.
Yes, sir, it is.
And when did you sign this document, Mr. Stevens?
Yesterday, sir.
And when you signed it, did you understand it was an agreement to plead guilty, and that means there won't be a trial? The next step would be a sentencing hearing?
Yes, sir.
And did you discuss this with your attorney and have her explain everything to you before you signed it?
Yes, sir, I did.
And do you feel you had enough time to fully consider the matter before making the decision?
Yes, sir.
And you haven't changed your mind since you've had a day or so to think about it? You're still wanting to go forward?
Yes, sir. I do have a couple questions for my attorney, though.
All right. I'll go ahead and put you into a breakout room then. So on the screen, it's going to pop up here in a moment, a button that's going to say Join Breakout Room. And when you see that, click on that. And I see the deputy stepped out of the room there.
Yes,
and
sir.
then when you're done, you'll click Leave the Breakout Room. And then you'll have to be readmitted. You'll come back up on my screen.
Okay,
and then let the deputy know when you're done. That way he can come back in.
All right, thank you.
All right, should come up momentarily.
Back on record.
All right, back on record on State versus Stevens. All right, Mr. Stevens, have you resolved everything to your satisfaction with your attorney's
Yes, sir.
advice?
Yes, sir.
All right, so we're still going forward, Ms. Hapner?
Yes, we are.
All right. And let's see here. All right. Now, Mr. Stevens, the charge in count one is under trafficking in a fentanyl-related compound under section 2925.03A1, a fourth-degree felony. And it says on page 1 that you understand that the possible prison term for that is between 6 and 18 months. A fine of $5,000 is possible. There's also a possible license suspension of 6 months, 5 years. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else at this time?
I have already signed a plea bargain in Clinton County with Judge Ruddick for probation. I go for sentencing on that at the end of this week.
And what is it? What is that charge?
Theft, F5 theft.
All right.
And he was just waiting to see what happened in your court.
Right. Okay.
So.
Now, are you on probation or community control or parole or post-release control for a felony besides that case?
No, sir.
All right.
No, sir.
Now, under the law, Mr. Stevens, if you should serve time for this offense, which is maximum is 18 months, upon completion of that term that would be imposed, if it were imposed, the adult parole authority does have the right under the law to exercise an option to put you under post-release control after you've completed your sentence, meaning you'd be supervised by a parole officer under the terms that they set, and if during that, and that could be for up to 2 years. And if during that period of time they determine that you'd failed to comply, they could return you to prison and make you serve an additional period of up to, 9 months for one violation, but there is a cap of half of your prison term for all violations. But if you commit a new felony while under post-release control, then in addition, whatever sentence could be imposed on you for committing that offense, that court could also order you to serve additional 1 year, whatever time is left on your post-release control, whichever is greater, and if that occurs, that has to be served consecutively to the sentence of the new case. Do you understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanctions, and that means instead of going to prison, you'll be supervised by a probation officer on the term set by the court for a period of up to 5 years. If during that period of time probation feels that you've not complied, they will file a written accusation or notice of that with the court. You'll be given a copy of that document. You'll have the right to have a hearing. You will have a hearing, and you will have the right to have an attorney at that hearing. And if the outcome of the hearing is you fail to comply, then the community control can be terminated. Then you can be sentenced to 18 months and fined $5,000. And if your community control were revoked because you were in all or in part because of a new conviction, then and you were sentenced for that new felony conviction to prison, that term of prison could be imposed to run consecutive to the term imposed in this case. You understand that?
Yes, sir.
All right. Now, the charge in count 1 alleges that on or about July 17, 2023 in this county, you did knowingly sell or offer to sell a fentanyl-related compound, a Schedule II controlled substance, an amount equal to or exceeding 1 gram or less than 5 grams, in violation of Section 2925.03A1. So that's the charge. Now, do you understand what it is you are accused of, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defense you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, the agreement states on page 2, there's several lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1. State will dismiss count 2. State and defense jointly recommend community control or referral to drug court. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay bond money to the task force in the amount of $100. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so even though there's a recommendation that you be granted community control and be referred to drug court, that's not binding on the court. Once I've heard all the information submitted, if I decide that's not the appropriate sentence, I could go ahead and sentence you to prison and fine you $5,000 and suspend your license for 6 months to 5 years. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept your plea. You have right to counsel. Ms. Hatton was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you're likely to provide. So, if you decide you don't want to do this, that you want to defend the charge, she'll continue to represent you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Hey, Dan, open that window back up. I'm getting hot here. All right, now, under the law, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, those 12 will hear all of the evidence and then be instructed on the law by the judge. And then that jury of 12 will decide by unanimous verdict, meaning all 12 have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning that the judge will be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront witnesses against you and to cross-examine through your attorney. What that means in open court. So what that means is that the witnesses against you have to come into the courtroom in front of you and your attorney and anyone else is present and testify. After the prosecutor's done asking them questions, your attorney has the right to ask questions. That's called cross-examination, the purpose of which is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Stevens, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order that's called a subpoena, and that forces them to come to court to be able to testify, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination in this matter. What that means is that you cannot be forced to give evidence at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. You decide not to testify. The fact you did not testify cannot be used or cannot be used against you in any way by any person, and no one can even talk about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you are presumed innocent of these charges until proven guilty by proof beyond a reasonable doubt by the state of Ohio on every essential element of the offense. So, the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you don't have to put on any evidence whatsoever at trial. You may, but you're not required to. But whether you do or not, the burden of proof will always be on the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation, denied you committed a crime, and exercised or invoked all the rights that I've described for you today. If you change that plea from not guilty to count one, that's the opposite of the not guilty plea. Guilty plea admits the allegation in the indictment, count one, admits that it's a crime, you committed that crime. And that plea waives, gives up all the rights that I described for you earlier, except one, your right to have an attorney. You always have a right to have an attorney no matter what your plea is, but with that exception, your plea of guilty would waive or give up your right to a jury or a court trial. Would waive or give up your right to confront witnesses against you and cross-examine them through your attorney. Would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, same as the state. Would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, that's what's used to find you guilty. Would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Plea of guilty subjects you to being sentenced immediately by the court, and it also waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing after being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
And did you enter into this agreement to plead guilty voluntarily and proceeding today voluntarily?
Yes, sir.
All right, do you have any questions about any of the charge or the possible penalty?
No,
Do you
sir.
understand it?
Yes, sir.
Do you understand the plea agreement?
Yes, sir.
And again, you understand that the recommendation on sentencing is not binding on the court.
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
All right. And is there anything else you need to speak with with your attorney about before we go any further?
No, sir.
You have any questions about anything that I've explained here today?
No, sir.
All right, then are you going forward and pleading guilty to count one pursuant to the terms of this agreement?
Yes, sir.
All right, then as to the charge, which alleges that on or about July 17, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, Schedule II controlled substance, an amount equal to or exceeding 1 gram but less than 5 grams in violation of Section 2925.03A1 of the Ohio Revised Code. The fourth-degree felony, carrying a possible prison term of 6 to 18 months, possible fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right. Court finds on this day in open court, defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Plea is accepted, order filed. Defendant is found guilty of count 1. Count 2 is dismissed. The court refers the matter to the probation department for a pre-sentence investigation report, as well as an assessment for substance use disorder treatment and/or mental health assessment. Bond will be continued. Matter is referred to the drug court docket as well. All right. Let's see, Ms. Hapner, May 1st, are you available May 1st? I thought we may have discussed
Yeah.
something.
Yeah, I've got it. I have a 10 o'clock in juvenile court, but I've got a couple sentencings at 9 o'clock.
All right, well, we'll go ahead and we'll get you done first. So, all right, so May 1st at 9 a.m.
Great, thank you.
All right, the probation department will be then in touch with you then, Mr. Stevens, thank you.
No, thank you.
All righty, now we'll go ahead and do,
Thank you.
this is case number 24-0002, State of Ohio versus Tammy L. Miller. You're Tammy L. Miller appearing there from the probation department.
Yes, sir.
All right, this is a matter set for plea. This matter is set for a pretrial tomorrow, and Ms. Abner contact Simon Commissioner to see if we can move it up, and so we're doing that here today. And this is being conducted by Zoom. Ms. Miller is appearing from the probation department. Appearing on her behalf as her counsel is Catherine Hapner from her office, and from the prosecutor's office is Annika Collins. Now, Ms. Miller, I know you've been watching the last hearing, so you kind of have an idea how this works, but just for the record, if at any time you need to talk to your attorney, you let me know, and I can put you and her in the breakout room, which you saw happen, and the two of you talk privately, and no one else can see you or hear you, okay?
Okay.
And then also, Ms. Hapner, are you and your client both in agreement the matter can be conducted by Zoom rather than in person?
Yes, we are.
And you're all right with that, Ms. Miller?
Yes.
All right, thank you. All right, Ms. Miller is charged with aggravated trafficking and aggravated possession of methamphetamine, and then also a forfeiture specification. And I have this agreement that says you're going to plead guilty to counts 1 and 2, and I'm going to hold this as a 3-page document that the prosecutor's office prepared. I'm going to hold it up to the camera and ask if you recognize the first page of that agreement with your name and case number, plea of guilty, and it says counts 1 and 2. See it there?
Yes, I do.
All right. And you recognize that?
Yes.
Then on page 3, there is a sentence about halfway down the page. It reads, I enter this plea voluntarily, and below that appears to me to be the signature Tammy Miller, and I'll hold that up to the camera. and ask you if that is in fact your signature.
Yes.
When did you sign this document?
Last Wednesday, I believe.
All right. When you signed it, did you understand it was an agreement to plead guilty, meaning there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes.
And did you have enough time to go over this matter, fully consider it before making the decision?
Yes.
You feel that you were rushed or pressured in any way?
No.
And you're entering into this agreement voluntarily?
Yes.
And you still want to go forward with this even though you've had a week or so to think about it?
Yes, sir.
All right. And you're doing that voluntarily?
Yes, sir.
All right. The agreement says you're going to plead guilty to counts 1 and 2, count 1 being aggravated trafficking in methamphetamine under 2925.03A2 of the revised code, a third-degree felony. Count 2 is a forfeiture specification, and that would seek to forfeit certain property that's listed in the indictment. I believe it's a vehicle, a 2008 Chevy SUV. And you understand that the possible penalty for count 1 could be a period of between 9 and 36 months in the increments provided by statute. And there could be a fine of $10,000. There is a mandatory fine of $5,000. Possible license suspension of 6 months to 5 years. And while prison is presumed to be a necessary sentence, that is not required. You understand all that?
Yes, sir.
Facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or post-release control for a felony from any court?
No.
All right, now, under the law, should you be sentenced to prison at some time for this offense, upon completion of that prison term, it is possible the Adult Parole Authority would put you under what's called post-release control for a period of up to 2 years. They don't have to, but they can, but it's up to them. And if they do, you'll be supervised under the terms they set by a parole officer, and if during that period of time they determine that you have not complied, then they can return you to prison to make you serve an additional period of up to 9 months for any single violation, although there's a cap or limit of half of whatever the prison term was for all violations. But if you're convicted of a new felony while under post-release control, then in addition to whatever sentence could be imposed in that new case, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right. Now, under the law, I'm not required to sentence you to prison, and so I could put you under what's called community control, meaning you'd be supervised by a probation officer for a period of up to 5 years under terms that are set by the court. If during that period of time they felt that you were not complying, they would file a written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney at that hearing, and if the outcome of the hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to prison term of between 9 and 36 months and fine you $10,000. And if your revocation and sentencing was due in part for, or totally due to a new conviction for a felony, then in addition to whatever sentence could be imposed for that new felony offense, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. Do you understand that?
Yes, sir.
Well, the charge reads that on or about December 15, 2023, in Huntington County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, Schedule 2 controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, when you knew or had reasonable cause to believe that it was intended for sale or resale by yourself or another, in violation of Section 2925.03A2. So that's the aggravated trafficking of methamphetamine charge. Count 2 alleges on or about the same date in Huntington County, Ohio, you had in your possession an owed 2008 Chevrolet SUV, and they have the VIN number in there, and that you transported the methamphetamine from Dayton to Columbus, or from Dayton to Greenfield in the SUV, and it's therefore subject to forfeiture due to instrumentality in the commission or facilitation of the offense as defined under Section 2941.14.17 of the Ohio Revised Code. And so that offense subjects that property being forfeited to the state. Now, Ms. Miller, do you understand what it is you've been charged with, what the state said you did, when, where, and how they allege that you did it?
Yes.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of the trial with your attorney?
Yes.
And are you satisfied with her advice and competence in this matter?
Yes, sir.
Has anyone, are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you in any way to make you plead guilty here today?
No.
Now, on page 2, there are about 3.5 lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1 and count 2. Defendant, state will dismiss count 3. State defense jointly recommend community control and substance abuse treatment. Defendant agrees to the forfeiture outlined in count 2. Defendant agrees to cooperate fully in prosecution of the co-defendant. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No.
Under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement that you plead guilty and get a certain sentence, once I've heard everything is submitted to me, if I decide that's not the appropriate sentence under the law and the evidence, you could be sentenced to a term of imprisonment, fine, and have your driver's license suspended. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any governmental agency that holds any or regulates any occupation or profession in Ohio?
No.
Now, you have certain rights you must understand before I can accept a guilty plea. You have a right to have counsel. Ms. Hatton was appointed to represent you because you did not have the funds to hire your own attorney. She wasn't appointed simply to work the case out, but provide any defense that could be available to you under the law that you'd like her to provide. So if you decide you don't want to do this, she'll continue to represent you and defend you, including a trial if that's what you want. You understand that?
Yes, sir.
Now, in the law and the Constitution, you have a right to have a trial by jury in this case, which means that 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They'd then be instructed on the law, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up your right to have a jury trial in writing. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes.
Right now, under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney in open court. What that means, witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are able or willing to come in voluntarily, it's your request. The court issues a court order that's called a subpoena, and that forces those people to come into court to be available to testify on your behalf if you want them to, even though they don't want to be here. And that's the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Now, in the Constitution, you have a privilege against self-incrimination, meaning you cannot be forced to give evidence of this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision, and if you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way, at any time, by any person. In fact, no one can even comment about it, with one exception. If there is a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge or these charges till proven guilty by the state of Ohio on every essential element of each offense by proof beyond a reasonable doubt. What that means is that the burden isn't on you to try to prove you're not guilty simply because you've been accused of a crime in these cases. In fact, under the law, you don't have to present any evidence at all at your trial. You may, but you're not required to, but whether you do or not, the burden of proof will remain on the state to prove your guilt on each offense by proof beyond a reasonable doubt on every element of each offense, and that is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Originally entered a plea of not guilty, which denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I just described. Change your plea from not guilty to guilty, that's the opposite of the not guilty plea. That plea denies or omits the allegations in each count that you're pleading guilty to, and that they are crimes, that you committed those crimes, and that plea waives, gives up all the rights I've described for you today, except the right to have an attorney, which you always have, no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront the witnesses against you and to cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case if you are sentenced to the maximum sentence or under the certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Do you have any questions about the charges or the possible penalties?
No.
You understand those?
Yes.
You understand the plea agreement?
Yes.
And again, you understand the recommendation on the sentencing is not binding on the court.
Yes.
You have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes, I understand them.
Have you had any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No.
You understand?
Yes.
Is there anything you need to speak with your attorney about before we go any further?
No.
Then is it your decision to withdraw your not guilty plea, plead guilty to counts 1 and 2 pursuant to the
Yes.
plea agreement we've just discussed?
Yes.
All right, then as to count 1, which alleges that on or about December 15, 2023 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, when you knew or had reasonable cause to believe it was intended for sale or resale by yourself or another, in violation of Section 2925.03A2, a charge of aggravated trafficking of methamphetamine, a third-degree felony with the possible penalties between 9 and 36 months in increments provided by law, fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
As to count 2, which alleges that on or about December 15, 2023, in Highland County, Ohio, you had in your possession and owned a 2008 Chevy SUV, VIN numbers in the indictment, transported methamphetamine from Dayton to Greenfield in the SUV, and the property is subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined under ORC Section 2941.14.17. The charge of specification of forfeiture, which means that the loss of that property to the state. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendant was advised of all of our constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal Rule 11. Please accept it in order to file. The defendant is found guilty of counts 1 and 2. Count 3 is dismissed. Matters referred to the probation department under the same bond for a pre-sentence report, which shall include an assessment for substance use disorder and/or mental health issues. And we will set sentencing on May the 1st at 8:45 a.m. You'll need to see the probation department there before you leave for an appointment for PSI. You're also going to be evaluated for substance abuse and/or mental health issues. And I see here from probation that you've tested positive on the 27th of February. Every time for methamphetamines and amphetamines and THC or marijuana, and then also on the 27th MDMA, which is ecstasy. Programming that's available, then it makes it less likely I'll follow the plea agreement and you could end up going to prison instead.
Okay.
You understand? Mr. Armstrong. And Ms. Collins, has the alleged victim of the offense been notified of the time, place, and purpose of this hearing?
Yes, the officer has advised that he would not be attending.
All right.
And the other victim
whose vehicle was hit, also has advised that she will not be attending.
Okay, so there's two here, okay, all right. All right, now, Mr. Armentrout, are you and your client both in agreement that this matter can be conducted by Zoom rather than him appearing in person in the courtroom?
We are, Your Honor.
And you're all right with that, Mr. Newsome?
Yes, sir.
All right, if at any time during this hearing you should need to ask an attorney a question or would like to talk with him, you just tell me. I'll put you and him into a breakout room. It'll be just the two of you talking. None of us will be able to see you or hear you. And while you're doing that, the deputy will step out of the room so that your session with your attorney is confidential. Okay?
Yes, sir.
All right.
I would like to speak with him for a second before we...
All right. All right, I'm going to put you and him into the breakout room. In a second or two, there will be a button that'll pop up that says join breakout room, and you click on that. And then when you're done, click leave breakout room, and that'll bring you back to request to be readmitted into the hearing. And then you can tell the deputy and they'll step back into the room, okay?
Yes, sir.
All right, it should come up momentarily here.
Got it.
Go ahead and put us on.
Can you still hear me, Judge?
Yeah.
Do you have to back all the way out and then put the numbers in again? That's what I always seem to do. Is there a quicker way to get back?
No, there used to be, but they changed it, and I don't know, we've tried to figure it out, and they keep saying there's a button on the screen, but it never shows on our screen.
Okay.
So you'll leave the meeting and then have to rejoin.
Okay. We're fine to proceed, Judge.
All right. All right, now, Mr. Newsome, I have this agreement here, which indicates you're going to withdraw your not guilty plea, plead guilty. I'm going to hold it up to the camera. It says you're pleading guilty to count one, the sole count in the indictment. You recognize that form?
Yes, sir.
And on page 3, there's a signature line, or I mean a sentence about halfway down that says, enter this plea voluntarily. Right below that appears to me to be signature Mike Newsome. Hold that up to the camera, and is that in fact your signature?
Yes, sir.
When did you sign this document, Mr. Newsome?
This morning.
And when you signed it, did you understand it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing?
Yes, sir.
And did you have him go over and explain everything to you before you signed it?
Yes, sir.
Did you feel that you were rushed or hurried in any way into doing this?
No.
You had plenty of time to consider it?
Yes, sir.
And since it's been a few hours since you signed it, have you changed your mind, or do you still want to go forward with this?
Go forward, John.
And you're doing this voluntarily?
Yes, sir.
All right, now the agreement states that you're pleading guilty to the single count of failure to comply with the order of single police officer under 2921.331B of the Ohio Revised Code, a third-degree felony. Further states you understand that the maximum prison term for that could be 36 months. The minimum is 9 months. There's certain increments in between. There's a fine available of up to $10,000. There is a mandatory license suspension of 3 years to life, although you can get driving privileges. It is, if you have this offense conviction and another offense and receive penalty of imprisonment in the other offense, then this terms, under the law, those terms must run consecutively to each other. Do you understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
Not that I know of. I ain't been charged with.
Okay.
I ain't got the paperwork on anything.
Okay. And are you currently on probation, community control, parole, or post-release control for a felony?
PRC.
All right. And let me look in here. Do we have notice of that in the file?
Yes, it was filed March the 11th, Judge.
March the 11th?
Yes.
All right. All right. And that says that as of March the 7th, you had 567 days left on your PRC. And so there's been 24 in March, and 2 today is 26 days passed since that date. So that would mean you currently have 567 minus 26 would be 541, I believe. So that'd be 541 days that are left on the PRC. And if you're convicted of this offense and sentenced to prison, then that term would be invoked, and you'd be required to serve it consecutively to any sentence that I impose in this case. Do you understand that?
Yes, sir.
All right. Now, other than PRC, you're not under probation, parole, or community control, or post-release control for any other court?
Just PRC.
All right. Now, under the law, once you complete any prison term that's been imposed for this, it is mandatory that you be placed under PRC again. And for this offense, it has to be for at least 1 year, and it could be up to 3 years, as determined by the Adult Parole Authority. And you'll be supervised, as you know, by a parole officer. And if during that period of time the parole authority finds that you are not complying, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of the prison term for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, the judge is also authorized to sentence you for committing that offense under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And that sentence would be ordered to be served consecutively as sentence in the new case. You understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison, although that is presumed to be the appropriate, no, there's no presumption here. So I'm not required to sentence you to prison. I could give you community control, which is probation, is what most people know it to be. That means instead of going to prison, you're put under the supervision of a probation officer on the term set by the court for a period of up to 5 years. If during that period of time the probation department feels you're not compliant, they'll file a written notice that with the court. There will be a hearing. You'll be entitled to have an attorney at that hearing to represent you. If the outcome of that hearing is you fail to comply, then the court can revoke your community control, sentence you to 36 months, and fine you $10,000. And if you were terminated from community control because of a new felony conviction while under community control, then and you received a prison sentence for that new felony, that new sentence could be ordered to be served consecutively to the sentence in this case. You understand that?
Yes, sir.
All right, now the charge in the indictment alleges that on or about January 18, 2024, in Highland County, Ohio, you did operate a motor vehicle as defined in ORC section 4501 as to willfully elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender caused a substantial risk of serious physical harm to persons or property. Violation of section 2921.331B of the Ohio Revised Code, a third-degree felony carrying a possible prison term between 9 and 36 months in increments provided by law, and a fine of $10,000 and a mandatory license suspension of 6 months to 5 years. Now, Mr. Newsome, do you understand what it is you're charged with, what the state said you did, when, where, how they alleged you did it?
Yes, sir.
You discussed the nature of the charge, the evidence in the case, possible defense you might try to raise at trial, possible outcomes of a trial, possible defense you could raise at that trial with your attorney.
Yes, sir.
And are you under the influence of any, or are you satisfied with his advice and competence, first of all?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to get you to plead guilty?
No, sir.
On page 2, there's a little over 2 lines printed in bold and underlined that read as follows. Defendant shall enter plead guilty to the indictment. State defense jointly recommend 18 months incarceration. State defense will argue sentencing. Which option is being chosen, Mr. Armentrout?
We're taking the recommended sentence, Your Honor.
All right. So that'll be stricken out by the court. And defendant shall pay full restitution. So the agreement, as I understand it, then, Mr. Newsome, is you plead guilty. State recommends 18-month sentence, which would, of course, be consecutive to your PRC time, and you'll pay the full restitution. Is that your understanding of the agreement?
Yes, sir.
Ms. Collins, do we know what the restitution is?
We do. It's a $500 deductible for a vehicle that he hit during this chase.
All right. And that's stipulated, Mr. Armentrout?
It is, Your Honor.
All right. Now, Mr. Newsome, the matter of sentence is up to the judge, not the parties. And so even though there's a recommendation that is what the sentence should be, I'm not obligated to follow that if you plead guilty. So, I could decide that the sentence should be anywhere between 9 and 36 months in increments provided by law, a fine of $10,000, and of course there's a mandatory license suspension, so I have to give that. You understand that?
Yes, sir.
All right. Now, do you hold any license or certification from any state government agency that regulates any occupation or profession in Ohio?
Not at this time.
All right. You have you have constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel, and Mr. Armentrout was appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you'd like him to provide. So, if you decide that you do not want to do this, he will continue to represent you and defend you, including a trial if that is what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people will be selected as a jury from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence will be presented, and then the judge would instruct them on the law. And then that jury would then decide by unanimous verdict, meaning all 12 would have to agree on the verdict, as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means give up your right to have an attorney. I'm sorry, your right to have a jury trial. And then in that case, you would have what's called a court or bench trial, meaning it would be the judge that would hear the evidence instead of a jury, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So, if you have witnesses you're not certain are going to be able to come in voluntarily, at your request, the court issues a court order that's called a subpoena. And that would force those people to come to court to be able to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, meaning you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it, except in one situation. If there's jury trial, you don't testify. The judge instructs the jury that because that's your right, you cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent until proven guilty of this charge by proof beyond a reasonable doubt on every essential element of the offense by the state of Ohio. What that means, the burden of proof isn't on you to try to prove you're not guilty because you've been accused by being indicted. In fact, under the law, you don't have to present any evidence at all in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described. If you change your plea from guilty to not guilty to guilty, that is the opposite. Not the guilty plea will admit the allegation in the indictment that you committed the crime, and that plea waives, gives up all the rights I've described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to confront the witnesses against you and cross-examine in open court through your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to come into court and testify for you, the same as the state. Waives gives up your right to a jury or court trial because you're saying you're guilty. It waives gives up your privilege against self-incrimination because you're saying you're guilty, so that's what's used to find you guilty. It waives gives up your right to a trial in which the state's required to prove your guilt by proof beyond a reasonable doubt, because if you say you're guilty, they don't have to prove you're guilty. It also waives gives up your presumption of innocence, as I said, because of that, and that means that you could be sentenced immediately by the court. And it also waives gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence, or under other limited circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, and also you would be subject to being sentenced immediately by the court. You understand that?
Yes, sir.
All right. Now, do you have any questions about the charge and the possible penalties?
No, sir.
You understand it?
Yes, sir.
You understand the plea agreement?
Yes, sir.
And you understand the sentencing recommendation is not binding on the court?
Yes, sir.
And you understand that if you're convicted and sentenced to prison, you could be sentenced to an additional 541 days for committing the offense while under post-release control.
Yes, sir.
You understand the constitutional rights I've explained?
Yes, sir.
You understand the plea of guilty, what it means, and what will happen if you enter that plea?
Yes.
Is there anything you need to speak to the attorney about before we go any further?
No, sir.
You have any questions about anything that we've talked about?
No.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the plea agreement?
Yes, sir.
Then as to the charge which alleges on or about January 18 in Highland County, Ohio, you did operate a motor vehicle as defined in ORC 4501.01 so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a halt or to a stop, and the operation of the motor vehicle by the offender caused a substantial risk of serious physical harm to the person's property in violation of section 2921.331B of the Higher Revised Code. The charge of failure to comply with the order of the police officer, signal of the police officer, a third-degree felony carrying a possible prison term of 9 to 36 months in increments provided by law, a fine of up to $10,000, and a mandatory life suspension of 3 years to life. How do you plead?
Guilty.
All right. Thank you. I need jail time credit. Court finds that on this date, open court, defendant was advised of all his constitutional rights and they made a knowing, intelligent, voluntary waiver of the same pursuant to criminal rule 11, please accept the order filed. Defendant is found guilty of the offense charged. Now, inasmuch as there's a stipulated sentence, the court will go ahead and proceed with sentencing. So there'll be no pre-sentence report. So anything further from the state?
Only what's contained in the plea agreement, Your Honor, and obviously the $500 in restitution. Thank you.
All right, who's that payable to?
It's payable to Savannah Rumfield, who owned a vehicle that was hit during
Okay.
the defendant hit.
All right. Mr. Armentrout?
I would ask the court to follow the recommendation of the state of Ohio. I can tell you that Mike has cooperated with me. He didn't try to make any excuses or outrageous demands. He owned up to it the first day that I talked to him. Hopefully the court will follow that. The only thing that he asked me to convey beyond that on his behalf, and I told him that I don't think the court would do that, but he would ask the court to consider waiving the court costs in this matter. He doesn't have anybody to go into the clerk to set up a payment plan, and if anything would be put on his books, it's my understanding that that's taken, or at least part of, by the clerk first. Other than that, nothing more, Your Honor.
Anything you'd like to say, Mr. Newsome?
No, sir.
Well, you have quite a record reaching back to 1995, Mr. Newsome. How many numbers have you got?
I don't know, 5 maybe.
Yeah, at least that. All right. Well, it's a judge of the court that you be and are hereby sentenced to the Correctional Reception Center in Orion, Ohio, for a period of 18 months. And according to the sheriff, you were arrested on, looks like January the 19th. Is that correct?
Yes, sir.
All right. So as of, as of the 27th, that was 68 days. So today would be 4 plus 6 days. So it would be 74 days of jail time credit. And it is also ordered that the defendant be sentenced to the 541 days of time remaining on his post-release control supervision, and that pursuant to law, that time be served consecutively to the sentence in the new case. Now, upon completion of this prison term, Mr. Newsome, the law requires that you be placed under mandatory post-release control supervision for at least 1 year, up to a maximum of 3 years, as decided by the adult parole authority using their discretion. If during the period of time you're being supervised by the parole office under those conditions, the parole authority determines you're not in compliance, they can return you to prison, make you serve an additional period of up to 9 months for any one violation, up to a maximum of half your prison term, which would be the 9 months for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge would be able, just like in this case, to sentence you to an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. In this case, the time you had remaining on post-release control was more than 1 year, so that's why the court imposed the 541 days. Now, you're also ordered to pay the court cost for which judgment, grant, and execution is ordered. And if you do not pay those, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. And if that doesn't collect it, then upon completion of that sentence, not while you're in prison, but once you get out, the court could permit you to do community service and give you credit for each hour you work in this county in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. You're also to make restitution in the amount of $500 as a step. What was the first name again? Savannah Rumsfeld. And that is $500, and that's a substantive order, and it has to be paid through the Highland County Victim Witness Escrow account, and they'll charge you a service fee for that, and you'll be required to pay that. And that substantive order means it's not dischargeable in bankruptcy, and it doesn't go away if you serve your entire term. It's still part of the sentence and can be enforced through other means. All right, there will also be a mandatory license suspension of 3 years, and the court will order that to start as of today. All right, is there anything further from council?
No, Your Honor.
All right, thank you. All right, Tara, Ralph would be next, please. If you don't have Mr. Ralph there, we can go ahead and do Mr. Rose next, whoever's available. All right, Ralph's there. Case number 24, CR 37, State of Ohio versus Tara D. Ralph. Are you Tara D. Ralph appearing there from the jail?
Yes, sir.
All right, this is a Zoom hearing for a plea. This case is actually set for a pretrial tomorrow, but a request to counsel was moved up until this afternoon. Her attorney is William Armentrout, appearing from his office, appearing on behalf of the prosecutor's office, Prosecutor Collins. And Mr. Armentrout, are you and your client both in agreement the matter can be conducted by Zoom rather than in-person appearance?
Yes, Your Honor.
You all right with that, Ms. Ralph?
Yes, sir.
All right, if during this period of time, during the hearing, you need to talk with him or ask him a question, since you're not in the courtroom, you tell me, I'll put you and him into a breakout room where there'll be just the two of you on the screen. No one else will be able to see you, hear you, and the deputy will step out during your confidential consultation with your attorney. You understand that?
Yes, sir. Thank you.
All right, now, Ms. Ralph is charged, looks like in a 26-count indictment involving various drug offenses. Count 1 is also a corrupt activity charge. I've been presented with a plea form, Ms. Ralph, which indicates you're going to plead guilty. Counts 1, 10, and 21. This is a 3-page form. Actually, this one runs into 4 pages. I'm going to hold up the first page of the agreement to the camera on my computer to make sure you recognize that form. Do you recognize that form? And on page 4, there's a sentence about a third of the way down the page. It reads, "Enter this plea voluntarily." And below that appears to be the signature Tara Ralph, and I'll hold that up to the camera. And is that in fact your signature?
Yes, sir.
When did you sign this document?
This morning.
And when you signed it, did you know understand that it was an agreement to plead guilty, which means there's not going to be a hearing, and the next step in your case would be a sentencing?
Yes, sir.
And do you feel you had enough time to fully consider the matter before making the decision?
Yes, sir.
Were you rushed or pressured in any way to doing this?
No, sir.
You entered into the plea voluntarily.
Yes, sir.
And you still want to go forward this afternoon voluntarily with the plea?
Yes, sir.
All right, now the agreement states on page 1 that you're going to plead guilty to counts 1, 10, and 21. Count 1 is engaging in a pattern of corrupt activity under section 2923.32A1 of the Ohio Revised Code, a first-degree felony. Count 10 is trafficking in a fentanyl-related compound in the vicinity of a juvenile under 2925.03A1, a second-degree felony. And count 21 is trafficking in a fentanyl-related compound in the vicinity of a juvenile under 2925.03A1, a third-degree felony. Now, it states that you understand that as to count 1, there is a prison term that is mandatory of at least 3 years up to 11 years, as ordered by the judge, a fine of $20,000. Count 10, the second-degree felony, there's a possible prison term, mandatory term. And let me back up. Count 1's not mandatory. But count 2 is mandatory, and that would be 2 years to 8 years as ordered by the judge, with a fine available of $15,000, a mandatory fine of $7,500, and a license suspension of 6 months to 5 years. Ms. Collins, it says a mandatory term on count 1, but I didn't think it was.
It's not. Mr. King and I were just discussing that it's
I'm going
not.
to go ahead and put an X to that then,
Okay.
for the record. All right. Now, count 21 is trafficking in a fentanyl-related compound in the vicinity of a juvenile under 2925.03A1, and that's a third-degree felony, and that carries a possible prison term between 9 and 36 months. A fine of $10,000, mandatory fine of $500, and both that and count 2 or 10 carry possible license suspensions of 6 months to 5 years. Now, with regard to count 1, if you're convicted of that and sentenced to a term of incarceration, whatever term the court orders will be the minimum term, and it could be a number between 3 and 11. And under the law, the Reagan-Tokes law, which is referenced in your plea agreement, that law actually applies to both counts 1 and 2, but under the law, it can only be exercised for 1 count, and this is being the more serious offense, it would be as to this count. So what that means is any sentence that I impose on count 1 of between 3 and 11 years could be extended by the Department of Rehabilitation Corrections at their option after they analyze your case and your history and so forth. And if they decide that should be extended, then your sentence could be 50% more than whatever term I impose. So using an easy example, let's pick a number right in the middle. If I gave you 6 years on the offense, DRC could extend that up to 9 years, add 3 years to it. Worst case scenario, if I give you the 11 years, they could add 5.5 years. So that'd make your sentence 11 to 16.5 years. Best case scenario, if you got a minimum sentence of 3 years, they could add up to half or a year and a half, making it 4.5 years. So in that case, your sentence would be 3 to 4.5 on that particular charge. You understand that?
Yes, sir.
All right. Now, on count 2, that sentence is mandatory. So when any sentence I impose is mandatory, and that sentence would be served first. And then the other sentences that are imposed would be served after that. And then there's also a possible sentence on count 21 of 9 to 36 months. So adding those maximums together, that's a 3 years maximum on count 21, 8 years on count 10, so that's a maximum of 11, and 11 years on count 10 is 8 years, so 8 and 3 are 11, plus 11 on count 1 makes it 22, would be the maximum prison term, with the possibility that if it were 11 years in count 1, it could be extended by another 5.5 years, making it 27.5 years. Yeah. There's also then a maximum fine available if you add all the fines together of $45,000. You understand all that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir.
And are you on community control, probation, parole, or post-release control for a felony?
No.
All right. Now, in this case, if you are convicted of these charges, it is mandatory that you be placed on post-release control on count 1 as a first-degree felony for at least 2 years, up to a maximum of 5 years after you're released and serve the term. What that means is that the adult parole authority will set down certain conditions, and a parole officer will supervise you. And if during that period of time they find you've failed to comply, they could return you to prison to make you serve up to 9 months for any one violation, but there is a cap or limit of half of the prison term that the court imposed for all violations. But if you committed a felony, then in addition to whatever sentence the judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time was left on your period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
All right, and again, community control or probation is not possible in this case because of count 2. You understand that?
Yes, sir.
Now, charge of count 1 alleges that on or about the period of April 1, 2023 through August 1, 2023 in Highland County, and as a continuing course of criminal conduct in Fayette County, Ohio, and Montgomery County, Ohio, you and other previously indicted and unindicted co-conspirators did recklessly, while being employed by or associated with, directly or indirectly, conduct or participate in the affairs of an enterprise through a pattern of corrupt activity. And at least one of those incidents of corrupt activity is a felony of the first, second, or third degree, in violation of section 2923.32A1. So that's the first degree felony, with the 3 to 11 sentence by the judge and the possibility of an additional 50% being added by the Department of Corrections, plus the fine of $20,000. Count 10 alleges that on or about June 2, 2023, in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, Schedule 2 controlled substance, an amount equal to or exceeding 5 grams or less than 10 grams in the vicinity of a juvenile. And so that's the second degree felony of trafficking a fentanyl-related compound in the vicinity of a jail, with a mandatory term of between 2 and 8 years, fine of $15,000, mandatory fine of $7,500, any possible license suspension from 6 months to 5 years. Count 21 alleges that on or about July 5, 2023, in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, a Schedule 2 controlled substance, an amount equal to or exceeding 1 gram or less than 5 grams in the vicinity of a juvenile, violation of section 2925.03A1, and that's the same charge as count 10, but it's a lesser offense because the amount involved is lesser. Third degree felony with a possible prison term of 9 to 36 months, fine of $10,000, mandatory fine of $5,000, and a possible license suspension. All right, now, Ms. Ralph, do you understand each of those charges, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
You discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney.
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty today?
No, sir.
Now, the several lines are on page 2 in bold and underlined, and I'll read as follows. Defendant shall plead guilty to count 1, count 10, and count 21. State will dismiss remaining counts. State and defense jointly recommend 3 years mandatory incarceration on count 1, consecutive to 2 years mandatory. Okay, well, that's not mandatory, but consecutive to 2 years mandatory on count 10, consecutive to 24 months incarceration on count 21. So that would be a total of 7 years, 2 of which are mandatory. You agree to cooperate fully with the task force, and you agree to repay the buy money in the amount of $3,140. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, Ms. Ralph, the matter of sentencing is up to the judge, not the parties. And so even though there's an agreement that you should be sentenced to a specific term, that's not binding on the court. And so if you plead guilty, I don't have to sentence you to that term recommended. I could, as I indicated earlier. I think if I ran everything concurrently, the minimum sentence would be 3 years to 4.5 years if I ran everything concurrently. Well, it could be 8 years on, but I'm just assuming that I pose that sentence. But anyway, minimum could be 3 years, and then the maximum could be, as I described earlier, 27.5 years. You understand that?
Yes, sir.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation, trade, or profession?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have an attorney, and I believe Mr. Armentrout was appointed by the court because you were unable to pay your own attorney. And so, if you decide you do not want to do this, that you still want to defend against the case, he'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to you have a right to a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned, that live in Highland County, summoned for jury duty on your trial date. After they are selected, the evidence will be presented, they'd be instructed on the law, and then that jury would decide by unanimous verdict, between all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, and that means instead of a jury hearing the evidence, the judge hears the evidence, the judge applies the law, and the judge decides whether or not the state proved your guilt. Do you understand that?
Sir.
Now, under the Constitution, you have a right to confront the witness against you in open court and cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. You understand that?
Yes, sir.
Now, under the Constitution, you have privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you decide not to testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offenses charged. So what that means is that the burden isn't upon the state to prove that you're not, the burden is not upon you to prove that you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any testimony or evidence in your own defense at trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each offense, which is the highest burden of proof is known under the law. Do you understand that?
Yes, sir.
Right now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and then exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed that crime. And that plea waives or gives up all the rights that I've just described for you, except one, your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or a court trial. It waives, gives up your right to confront witnesses against you in open court and cross-examine them through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. It waives, gives up your presumption of innocence because you say you're guilty. That's what's used to find you guilty, and the state doesn't have to prove you're guilty. Again, waives your privilege against self-incrimination because your guilty plea is incriminating yourself, which is what's used to find you guilty. It also subjects you to being sentenced immediately by the court, which is what's likely here since it's mandatory time. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence, or under certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen, Ms. Ralph?
Yes, sir.
All right, now do you have any questions about the three charges as proposed you plead guilty to, or the possible
No.
penalties? Do you understand
sir.
them?
What is it?
You understand them?
Yes, sir.
And you understand the terms of the plea agreement?
Yes, sir.
And again, you understand that the recommendation on sentencing is not binding on the court?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No,
You
sir.
understand those?
Yes.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea?
No, I don't have any
You
questions.
understand that?
Yes, sir.
Okay. Do you need to speak with your attorney about anything before we go any further?
I don't think so.
Do you have any questions about anything I've explained to you here today?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge, three charges that we've gone over pursuant to the terms of this plea agreement?
Yes, sir.
And you're doing that voluntarily?
Yes, sir.
And I don't know if I asked you, are you a U.S. citizen?
Yes, you, sir.
Okay. All right. Then it's your decision to go forward?
Yes.
All right, then is count one, which alleges an on or about the period of April 1, 2023, continuing through August 21, 23, in Hiding County, Ohio, and is continuing course of criminal conduct in Fayette County, Ohio, and Montgomery County, Ohio. You and other previously indicted and unindicted co-conspirators did recklessly while being employed by or associated with, directly or indirectly, conduct or participate in the affairs of an enterprise through a pattern of corrupt activity, and at least one of the incidents of corrupt activity is a felony in the first, second, or third degree in violation of section 2923.32A1 of the Ohio Revised Code, charge of engaging in a pattern of corrupt activity, a first-degree felony, carrying a possible prison term between 3 and 11 years is set by the judge, with the possibility that could be added to by up to 1/2 by the DRC. With a fine of $20,000, how do you plead?
Guilty.
Now is to count 10, which alleges on or about June 2, 2023 in Highland County, Ohio, you didn't knowingly sell or offer to sell a fentanyl-related compound, a Schedule II controlled substance, an amount equal to or exceeding 5 grams or less than 10 grams in the vicinity of a juvenile, violation of section 2925.03A1 of the Ohio Revised Code, a felony of the second degree carrying a mandatory term of at least 2 years up to 8 years is set by the judge, a fine of $15,000, a mandatory fine of $7,500, and a possible license suspension for 6 months to 5 years. How do you plead?
Guilty.
And then as count 21, which alleges that on or about July 5, 2023 in this county, you did knowingly sell or offer to sell a fentanyl-related compound, a Schedule II controlled substance, an amount equal to or exceeding 1 gram but less than 5 grams in the vicinity of a juvenile, violation of section 2925.03A1 of the Ohio Revised Code, a charge of aggravated, I forgot what it was now, trafficking in a fentanyl-related compound in the vicinity of a juvenile with a third-degree felony, possible prison term between 9 and 36 months, fine of $10,000, mandatory fine of $5,000, and a possible life suspension for 6 months to 5 years. How do you plead?
Guilty.
All right. Court finds on this day in open court, the defendant was advised of all of her constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted and ordered filed. Defendant is found guilty of counts 1, 10, and 21 as set forth in the plea agreement. The remaining counts are dismissed. Court will not order a pre-sentence report given the mandatory term and the nature of the offenses and the number of transactions, so I'm going to proceed with sentencing forthwith. Anything from the state regarding sentencing?
Only what's contained within the plea agreement, Your Honor.
Mr. Armentrout?
I would ask the court to follow the recommendation made by the state of Ohio. I would say on behalf of Tara, she very much cooperated with me. There was never anything, I didn't do this, give me a trial, I'm taking it to trial. I would note that it's still over a month to the scheduled trial date. It has moved along fairly rapidly, and that's all to her credit. She wanted to step up to the plate and own up to what she had done here, which is what she has done today. So I would ask the court to follow the recommendations, Your Honor.
Anything you'd like to say, Ms. Ralph?
No, Your Honor.
Well, Ms. Ralph, I mean, this is a really big operation. 26 counts is quite a few for one person. You know, I just sentenced another person to, I believe, 11 years, 14 years total, although 2 of those is because he didn't appear, 13 years total because he didn't appear. He does have a previous record, a couple of previous records, has been a drug dealer most of his life, but your record shows, you know, 3 prior felony convictions and, you know, 25, well, it'll be 12 transactions. With the amount of money involved, that's not a small amount. I think, though, that the damage that you can do and have done in this community is probably just as great as what he did. And so I'm going to, I'm not going to follow precisely the agreement. The order of the court, that is to count 1, that you be sentenced to a term of 3 years. And a plea agreement says that's mandatory. I'm going to strike that out on page 2 because I might get a call from the Bureau of Sentence Computation saying, hey, you just screwed up, because they read these things. Well, somebody reads them. I don't know who. But anyway, that'll be a 3-year term, and that is not mandatory because it's not mandatory under the law. And I also struck it out on page 1. after the council agreed. With regard to count 2, I'm going to sentence you to 4 years of mandatory incarceration. And all that'll have to be served, and I believe by law that'll be served first, prior to the sentence of count 1 and count 3. As to count 1, I'm going to sentence you to 12 months incarceration. All those sentences are to be served consecutively, so that'll be a total of 8 years. Now, with regard to count 1, because that is a first-degree felony, and that is the count on which the DRC would have the authority, if they choose to exercise it, to extend your sentence. And so the sentence total is 8 years, 4 mandatory, plus an additional 4 years. And the DRC could extend that 3-year sentence to up to 1.5 years, meaning that the maximum sentence could be 9.5 years, if they do that. Now, I believe the...
Judge,
Sorry?
that is not, there have been just several things I want to correct. It's count 1, count 10, and count 21,
Yeah,
not
I'm
1,
sorry.
2, and 3.
What did I say?
1, 2, and 3.
I'm sorry. Count 1 is 3 years. Count 10 is 4 years mandatory. And count 21 is 12 months. Thank you. I had it written down.
I'm sorry. And then Reagan-Tokes law applies to the longest sentence, not the highest degree felony.
Okay. All right.
So
then that
count
means
2.
it could be extended by 2 years, meaning
Yes.
it would be a maximum of 10 years. That's right. It does extend to the longest sentence, not to the not to the largest one. Right. Okay. All right. Now, thank you. Now, I believe you were arrested on January 31st. Is that correct?
Yes, sir.
All right. And so, according to the sheriff, as of March the 27th, that was 55 days. So that would be 6 more days, 4 in March and 2 today. So that'd be a total of 61 days of jail time credit. Now, the court finds that consecutive sentences are required for several reasons. First, it is a negotiated agreement and a joint recommendation, stipulated sentence of consecutive sentencing. Second, the offenses were committed as part of a series of misconduct, or maybe one continuing conduct, since it's a count 1 is an engaging in a pattern. But it's numerous transactions, and one single sentence would not adequately reflect the seriousness of the crime nor the harm caused, and the sentence that has been imposed by the court is not disproportionate on any of the counts to the harm caused. The count 1 being a minimum sentence, count 2 being the median sentence, and count 3 being the next to the lowest sentence. And further, this defendant's criminal history, as I've indicated, with the several drug offenses and thefts and other charges, misdemeanor charges, over a period of years, demonstrates that consecutive sentences are necessary to protect the public from future crime by the defendant. Now, has there been any change in your financial circumstances since I appointed Mr. Arbitrout to represent you?
No.
All right. Well, the court then will waive the mandatory fine in counts 10 and count 21 and will not impose those. And the court will not impose a driving suspension on either count 10 or count 21. Now, it's also ordered that as a substantive order, you make restitution to the task force in the amount of $3,140, and that'll be payable through the Hiding County Victim Witness escrow, restitution escrow account, and you'll pay any fees associated with that, and that will survive your prison term because it's a substantive order. It cannot be discharged in bankruptcy, and so you will have to pay that, and it can be enforced through other means, including contempt if you have the ability to pay and don't pay it in the future. All right, is there anything further, counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded to custody. Thank you. All right, Don Rose Jr. right, this is case number 24 CR 25, State of Ohio versus Don Lester Rose Jr. Are you Don Lester Rose Jr. appearing there from the jail?
Yes, sir, I am.
All right, this matter was set for a pretrial tomorrow. At the request of the council, the court moved it up to this afternoon because we have quite a heavy caseload tomorrow, and so it's being conducted today. Mr. Rose is appearing from the jail. His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. And Mr. Armentrout, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person hearing?
We are, Your Honor.
And Mr. Rose, you're all right with that?
Yes, sir.
All right. Now, if at any time you need to talk to your attorney about something, since you're not seated next to him, you just tell me, and then I can put you and him into a breakout room where there'll be just the two of you on the screen. No one else will be able to see you or hear you. The deputy will step out of the room during your consultation so that it's confidential. Okay?
Yes, sir.
All right. Mr. Rose is indicted with, in a 4-count indictment with 2 counts of aggravated trafficking in methamphetamine, 1 in the vicinity of the school zone, and 2 counts of aggravated possession. Mr. Rose, have been presented with a plea of guilty form, which indicates you're going to plead guilty to counts 1 and 3. This is a 4-page form that the prosecutor's office prepares, and I'm going to hold up the first page to the camera and ask if you recognize that. It has your name, case number, plea of guilty, and says counts 1 and 3. See that?
Yes, sir.
All right. And you recognize that?
Yes, sir, I do.
And then on page 4, right at the top of the page, the sentence that reads, I enter this plea voluntarily. And right below that appears to be signature Don Rose Jr. Ask if that is your signature there.
Yes, sir, it is.
When did you sign this agreement, Mr. Rose?
Today, I'm sorry, this morning. I apologize.
All right. Now, before you signed it, did you go over it with your attorney and have him explain everything to you?
Yes, he went over with me. Yes, sir, he did.
And did you understand that it was agreement to plead guilty, meaning there's not going to be a trial, and the next step in your case will be a sentencing?
Yes, sir.
And do you feel you had enough time to fully consider the matter before making this decision?
Yes, I was well aware of everything. It's been took care of pretty good.
All right. And did you enter into the agreement to plead guilty voluntarily?
Yes, sir.
And are you going forward this afternoon voluntarily?
Yes, sir.
All right. So as we indicated, the agreement says on page 1, you're going to plead guilty to count 1 and 3. Both are aggravated trafficking in methamphetamine and violation section 2925.03A1. But the first count is more serious because it's alleged it was committed in the vicinity of a school zone, whereas count 3 was not. So count 1 is a second-degree felony, and count 3 is a third-degree felony. It states that you understand that the maximum penalty on count 1 is a sentence of anywhere from 2 to 8 years as imposed by the judge, and that would be a minimum term. And the DRC could, Department of Rehabilitation Corrections could determine that they would add to that if they felt it was appropriate for your case, up to 1/2 of that term. So if I give you the maximum sentence of 8 years, then they could add 4, making it 12, which would be your maximum. If I give you the minimum of 2, they could make it 3. And again, this offense is one in which the sentence that's imposed by the judge is mandatory. It has to be served. So there's no probation or community control or judicial release on that charge. There's also a fine of up to $15,000, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. You understand all that?
Yes, sir, I do.
Count 3 is a third-degree felony, and it carries a possible prison term between 9 and 36 months in certain levels provided by law. There's a fine of up to $10,000, a mandatory fine of $5,000, and also a possible license suspension of 6 months to 5 years. And while the prison term is not mandatory in this case, it is presumed necessary. You understand that?
Yes, sir.
Now, under the law, if you're convicted of both offenses, you could receive consecutive sentences, meaning one after the other. And so, giving you the worst case scenario, if you got 8 years on count 1 and 36 months on count 3, that's 3 years, 36 months. So that means it's a total of 11 years. And if that were the sentence, then the DRC decided to add a maximum 1/2 to that first count, they could make that an additional 5.5 years. So if you add that to the 11 years, that means the sentence could be 11 to 16 and a half. If the sentence were the minimum sentence of 2 years on count 1 and 9 months on count 3, and they were to be served concurrently, that means the minimum sentence would be 2 years, and the maximum sentence could be 3 if 1/2 was added to the sentence on count 1. So that's the range that you're looking at having as a possible sentence. You understand that?
Yes, sir, I do.
Other than these 2 charges, are you facing any felony charges anywhere else?
Possession in Montgomery County.
All right. Well, if you are convicted on that offense and sentenced to serve a prison term, it could be ordered to be served consecutively to the term in these cases. Do you understand that?
Yes, sir, thank you.
All right. Now, under the law, once you complete your prison term on these offenses, and again, first count is mandatory, so it'd be served first, and then the second one will be served. Upon completion of that prison term, it is mandatory that you be put under post-release control supervision by the adult parole authority for at least 18 months, up to a maximum of 3 years. So you'll be supervised by a parole officer by the terms that they set, and if they determine that you've not complied, then they can return you to prison and make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But should you commit a new felony, then in addition to whatever sentence the judge in that new case can impose upon you, the judge is also authorized to sentence you for committing that offense under post-release control, in this case, to an additional period of a year, or whatever time is left on the post-release control, whichever is greater, and that would have to be served consecutively to the sentence of the new case. You understand that?
Yes, sir.
And I think I may have skipped this, but are you currently on community control, probation, parole, or post-release control for a felony?
No, sir, I ain't.
All right. Now, the charge in count 1 alleges that on or about August 21, 23, in Hynek's County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in the city of a school zone, in violation of Section 2925.03A1 of the Ohio Revised Code. So that's the first count, which is the second-degree felony with the penalties I just described. Count 3 is the same offense in the same language, with 2 exceptions. First, it's the date that it's alleged to have occurred is August 28, 2023. And secondly, it does not have the allegation at the end that you did that in the vicinity of the school zone. And so otherwise, it's the same offense, but the penalty is a third-degree felony, as I explained earlier, instead of a second-degree felony in count 1. Now, Mr. Rose, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand the maximum possible penalties for the offenses?
Yes, I do.
Have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, I am.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir, I haven't.
Now, on page 2, there are several lines printed in bold that read as follows. Defendant will enter a plea of guilty to count 1 and count 3. State will dismiss remaining counts. State defense jointly recommend 2 years mandatory incarceration on count 1, consecutive 24 months incarceration on count 3. State will not oppose judicial release to substance abuse treatment after 2 years incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force the amount of $280. Is that your understanding of the agreement?
Yes, sir, I do.
Anyone promise you anything other than that to get you to plead guilty?
No, sir.
Under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement as to what the sentence ought to be, if you plead guilty, once I've heard all the information submitted, if I decide that's not the correct sentence, I could impose the maximum sentence of 8 years in count 1 and 36 months or 3 years in count 3 consecutive for a total of 11. Do you understand that?
Yes, sir, I do.
All right. Likewise, the matter of judicial release is up to the judge, not to the parties. So even though the state's saying that they will not oppose your judicial release after you've served the 2-year mandatory, if that's what the sentence is, that is still up to the judge. You understand that?
Yes, sir.
All right. Now, do you hold any license or certification from any kind of state governmental agency that regulates any occupation or profession in the state of Ohio?
That's okay.
It'd be
No,
something
sir.
like being a vet tech or a barber or a hospital aide or something like that?
No, sir, I don't.
All right. Now, you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel. Mr. Hermantrout was appointed to represent you, and that appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you'd like him to provide. So if you decide you do not want to do this, he will continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
Yes, sir, I do.
Now, under the law, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then the judge would instruct the jury on the law, and then they would decide whether or not the state proves your guilt by unanimous verdict on each count, meaning all 12 would have to agree on a verdict in each count. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else who may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Rose, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, court issues a court order, is called a subpoena. That forces those people to come to court to be available to testify if you want them to, even though they don't want to be there or be involved, which is the same way the state's witnesses are forced to come in to testify against you. You understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, meaning you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it, with one exception. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a presumption of innocence, which means that you cannot be forced, that you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offenses charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at trial to defend yourself. You may, but you're not required to. Whether you do or not, the burden of proof remains upon the state to prove your guilt by proof beyond a reasonable doubt on each of the essential elements of each offense, which is, and it has to be by unanimous verdict. That's the highest burden of proof that's known under the law. You understand that?
Yes.
Right now, Mr. Rose, when you originally entered a plea of not guilty, that plea denied the allegation in the indictment, denied you committed a crime, and it exercised or invoked all the rights I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea, as to these two counts. And that plea would waive or give up all the rights I've described for you, except the right to have an attorney, which you always have no matter what your plea. Both that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and to cross-examine them through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because you say you're guilty, the state doesn't have to prove you're guilty. It waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if you are sentenced to a maximum sentence, under limited circumstances, you can file an appeal. Any appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
All right. A plea of guilty would also subject you to being sentenced immediately by the court, which is what's likely to happen since there's a mandatory term. Do you understand that?
Yes, sir, I do.
All right. And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalties, Mr. Rose?
No, sir, I don't.
You understand both?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, I do.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand them?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand?
Yes, sir.
Is there anything you'd like to speak to your attorney about before we go any further?
No, sir, I don't.
All right, do you have any questions about anything that I've explained here for you this afternoon.
No, sir.
Then is it your decision to withdraw your not guilty plea to counts 1 and 2 and enter pleas of guilty to those offenses pursuant to the plea agreement that we've just gone over?
Yes, sir, I'm guilty.
All right, then as to count 1, which alleges that on or about August 21, 23 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance in an amount equal to or exceeding bulk amount but less than 5 times bulk amount in the vicinity of the school zone, violation of Section 2925.03A1 of the Ohio Revised Code, a second-degree felony, carrying a mandatory prison term of between 2 and 8 years set by the judge, with the possibility that could be extended by additional 1/2 by the Department of Rehabilitation and Corrections, a fine of $15,000, mandatory fine of $7,500, and a possible license suspension from 6 months to 5 years. How do you plead?
Guilty.
As to count 3, which makes the same allegation except the date was August 28th instead of the 21st, 2023, and that sale did not involve being committed in the vicinity of the school zone, but otherwise the same offense with the same language, a third-degree felony with the possible penalty of 9 to 36 months as increments provided by law, imprisonment, fine of $10,000, mandatory fine of $5,000, and possible license suspension of 6 months, 5 years. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendant provides all his constitutional rights made no intelligent voluntary waiver of those pursuant to criminal 11. Please accept an order filed. Defendant is found guilty of counts 1 and 3 as charged, counts 2 and 4 dismissed. Now, inasmuch as there's a mandatory prison term, the court will go ahead and proceed with sentencing. So is there anything from the state regarding sentencing?
Only what's contained within the plea agreement, Your Honor.
All right, Mr. Armentrout.
I would ask the court to follow the a recommended sentence. As in the previous case, Don's completely cooperated. It's still well ahead of the trial date. He owned up to it from the first time I had a meeting with him. Took responsibility. Would ask the court to follow the agreement.
All right, thank you. Mr. Rose, anything you would like to say?
No, sir, thank you.
All right, now, according to the sheriff, you were arrested on the 14th of February, is that correct?
Yes, sir.
All right. All right, then it is a judgment order of the court that defendant B is hereby sentenced to a term of 2 years mandatory incarceration as to count 1, with the possibility that could be extended by the Department of Rehabilitation and Corrections by 1/2, so up to a maximum of 3 years. That sentence is to be served consecutively to the count 3, and the sentence on that imposed is 24 months. Count 2 will be served first, since it's mandatory. The Sheriff's Department shows a rest date of February 14th, so that would be 48 days of jail time credit against that sentence. Now, the court imposes consecutive sentences because the parties have stipulated to that, and the offenses are committed as part of one or more series of conduct, and one single sentence would not adequately reflect the seriousness of the offense or the harm it's caused, and the sentences that are being imposed are relatively minimal, and so they're not disproportionate to the seriousness of the offense. And also, I was just looking here at I was looking for the discovery. Defendant has had one previous felony conviction for possession of heroin in Highland County. All right, and so the criminal history demonstrates that that's necessary for protection of the public. Now, upon completion of the prison term, Mr. Rose, it's mandatory that you be placed under post-release control because of your conviction on count 1 to a period of at least 1 year or 18 months and up to a maximum of 3 years, which means you'll be supervised by a parole officer, and if during that period of time they determine that you've not complied, they can return you to prison to serve an additional period as a sanction of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence the judge in that new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively as sentence in the new case. You're also ordered to pay restitution as agreed in the amount of $280 to the task force. That'll be payable through the victim witness escrow restitution account. You'll pay any fees required on that. And that is not a fine that can be discharged, or it'll continue to be there even if you serve your entire prison term, and could be enforced in the future through legal action. Has there been any change in your financial circumstances since your arraignment?
I still have no money.
Did you win the lottery, or anybody leave you $1 million or anything?
No, sir.
All right. Then a court will find that you do not have the ability to pay the mandatory fine, and that court will waive that. Court will not impose any suspension for driving. And then, if I didn't say it already, counts 2 and 4 are dismissed. All right. Is there anything further from counsel?
No, Your Honor.
All right. You're remanded to custody then, Mr. Rose. Thank you.
Thank you, sir.